So tonight on African Perspective, as I mentioned, we speak to South Africa's Public Protector Advocate Busisiwe Mkhwebane, who's also the president of the African Ombudsman and Mediators Association. This is a continental body of 40 public protector type organizations. It exists to advance the ideals of good governance and human rights in Africa by supporting and protecting the independence and development of ombudsman institutions on the continent. Welcome and thank you so much for joining us, Advocate Mkhwebane.
Thank you, and evening to your viewers. Thank you for inviting me.
So let's just start with AOMA. Perhaps if you could just familiarize our viewers, what is, I mentioned briefly what it's about, but what your core values are, what are you focusing on?
African Ombudsman and Mediators Association was established, in fact, actually as an African Ombudsman Association in 2003. But then after the African Union was formed, then it added the French-speaking countries, because in the French-speaking countries we've got what we call mediators, whereas all others we've got ombudsman or public protectors. Therefore, these institutions are there to assist in promotion of good governance, the rule of law, human rights, and also because we are mediators in our nature, assist Africa to silence the guns or bring peace and stability in Africa. So all these institutions are also provided for in Article 15 of the African Charter on Good Governance and Elections related matters. So our core values, all of us, are based on the O.R. Tambo principles governing ombudsmanship, which is all these institutions should be provided for in the constitution of the country. They should be independent, their autonomy should be maintained, they should have a guaranteed time frame in which the ombudsman should be operating, and they should be well resourced and be well funded.
And that, just in terms of independence, I'd imagine you speaking about being well resourced, some would argue that lack thereof then interferes with not only your ability to do your work, hold governments accountable, especially when you talk about good governance, but also be able to do so without fear or favor.
Yes, definitely, because I mean, if you rely on the very same fiscus or the same resources from government, our challenges as ombudsmen are similar, because you find that we are not well resourced and you depend on government and to provide the resources for you to do your work. Sometimes you'd find that the way some of the ombudsmen are remunerated, or their staff, which others, they depend on government to provide staff or second staff to the ombudsman offices. That indeed has an impact on doing our work without fear or favor, because at the end of the day you sometimes are at the mercy of the very same institution which you are supposed to be investigating. So I think the O.R. Tambo principles are also encouraging states, in fact government, all the countries, to make sure that these institutions are fully capacitated, so that this institution can assist them to achieve their aspirations.
What do you consider fully capacitated? This is something that you've lamented in South Africa, the lack of staff and other resources to be able to do a proper job, quote unquote, on some of your endeavors. And just looking at some of your principles, core principles of AOMA: integrity, reflecting that the ombudsman is being trusted, competent, honest, and reliable as an organization. All words that I'm sure you've become very familiar with in South Africa of late in terms of the criticism you have faced.
I would say that even if we don't have enough capacity or staff, but then the kind of or the quality of work which we produce is of high standard. Is not compromised because we don't have enough staff members, but it's just that our staff members are having a lot of work to do, and you find that then there's a delay in finalization of whatever investigations we having. Definitely, that also has an impact on the morale of the staff, or as well on the staff putting all their efforts in doing their work. Sometimes it might have an impact on the quality, but at the end of the day, that work won't be finalized or be published if it's not quality work.
What would undermine accountability and transparency in the Ombudsman being able to be true to those principles?
The very same thing I've mentioned of being fully resourced.
Okay.
Yes, I mean, if you don't have enough resources to do your work, for instance, it's not only relating to the staff. What systems do you have, especially your case management systems, whether you have enough resources or qualified expertise, because the kind of work we are doing, you need to have specialists in forensic investigations, expertise in procurement related matters, construction law. Those resources, if you don't have them, they delay your investigation, or at the end of the day, you find yourself having to finalize the matter and refer the matter to other institutions. Whereas if you could have those resources, then you can issue a report which is well researched, well investigated, also having a very or appropriate recommendations. But I must say that a lot of the other ombudsmen, their recommendations are still recommendations. It's not unlike in South Africa, where we have a constitutional court judgment which says our remedial actions are binding.
And I'm glad we're getting straight to that, because that is the meat of the matter. A lot of the criticism of late against you, some would say it's because of the adverse finding due to, some have labeled shoddy work. You have said it's because they question your powers, and some of these findings have undermined the power of your office. Do you still feel that way, having approached the Constitutional Court, or intending to, announcing that intention as of today?
You know, the judgment of the Constitutional Court, which was published, in fact, during the Nkandla judgment, that the remedial actions of the public protector are binding until set aside by a court of law. Again, I must repeat, the quality of our work is not shoddy. And if you can study all the reports which we have produced and the judicial reviews which have been brought against the public protector, are not even related to the merits of the investigations. You'll find that it's side issues or technical issues, or the process which is alleged to have been followed in producing those particular reports.
Okay, so let's talk about this latest case. You're approaching the Apex Court to review or appeal against a finding by the High Court on the remedial actions that you have suggested the President take against the Public Enterprises Minister Pravin Gordhan. And you've said that the High Court order was granted erroneously and bad in law. What aspect of that?
It's to correct you, is not the one where there's one which was brought by the President, and there's one which was brought by Minister Gordhan,
yes.
Especially to the interdict, where the
and that is the one that we're referring to.
Yes, of the rogue unit issued by Judge Potterell. So that relates to the judge aid in reaching the conclusion which she did. Because when you interdict a matter, you should be showing that prima facie or on the face of it, these are the issues which will have an impact to you as a person, or the balance of convenience which you need to take into account. So we've identified that that was not the issue. And you should remember that there was no one who asked for personal cost orders, but she decided to go ahead and issue that. And also there are requirements for a judge to issue a cost order or punitive cost towards a person. So those are issues which would want the Constitutional Court to clarify and the remedial actions of the Public Protector.
So we'll come to the punitive cost orders in just a moment, but I just want to understand, you're saying that if there's no direct appeal granted, you'll feel perhaps that the system has failed you, and you're saying that it is in the interest of justice that this is dealt with urgently. Why is that?
Yes, it's in the interest of justice. Remember, it also has an impact on the powers and mandates of the Public Protector. I mean, there's other matters which are before court, there's other interdicts. Therefore, we would want the court to pronounce on the, whether we still stick to the 2016 judgment, or to also be clear whether we would allow the process where it will just be recommendations like any other ombudsman in Africa, or who will issue recommendations, and it will be up to the very same state whether they implement those recommendations or they don't implement. And you should understand that other ombudsmen in Africa, the way the ombudsman operates, we're there to support and strengthen constitutional democracy. We're there to work with the state to show them the gaps and even recommend remedial actions to them. Hence, when we discuss the South African operations of the Public Protector, the difference is that due to the Constitutional Court judgment, then that's how we differ.
Okay. So then you're also going to another issue.
Also have a prosecutorial mandate, like Uganda, for instance. You'll find that they have that. The Rwanda one, they will have anti-corruption unit which operates, for instance, like the SIU in South Africa.
Public Protector, so that also raises another issue, the whole purpose of being able to take the Public Protector's remedial action under review. I want to go to the issue of the personal costs. You were saying in this particular case that the law does not make provision for that. So in the Constitutional Court ruling on the issue on the South African Reserve Bank, Justice Mkhwebane said this about bad faith conduct, that the Constitutional Court holds that personal cost orders against public officials like the Public Protector whose bad faith conduct falls short of what is required of them constitute essential constitutionally infused mechanism to ensure that they act in good faith. In other words, because of an adverse finding of the manner in which you conducted yourself, the court felt that it needs to issue this in order to discourage further such bad behavior. So are you saying that there is nothing in the Constitution or even within the justice system that allows for this?
You quoted me wrong. I never said there was nothing provided for in law. The Constitutional Court judgment was just confirming what the Pretoria High Court found. And again, there was no proof that I acted in bad faith, because if you act in bad faith, you need to have hidden certain records to the court. That has not been done. When I was submitting all the records to the Pretoria High Court, I submitted even records which were not even necessary for that particular investigation. And secondly, the Public Protector Act is very clear that the Public Protector and the Public Protector staff are immune from any civil litigation or such issues, because when we conduct our investigation, you would agree that, or you would know that the investigation was conducted for the past 6 or 7 years. But then, yes, the report was issued by the current Public Protector, and the work was done in good faith. The minority judgment, you could see that all the evidence we've submitted, all the explanations we've provided, those judges took their time to read the documentation, because it was explaining all the processes we followed. The very same issue that there were even handwritten notes, because if you've submitted even those, that is evidence. It doesn't mean that your evidence should be in recording, should be recorded, or should be transcribed.
So let's talk about that handwritten note, and we'll look at the minority court judgment, of which those two judges also did question about the punitive costs against you. But on that handwritten note, this is what the court found, the contradictory explanations, saying that the public protector's explanations are contradictory. On the one hand, the public protector said that meetings with the presidency had nothing to do with the substance of the content of the report, and that they did not discuss the remedial action recommended in the final report before its publication. On the other hand, she confirms that the handwritten notes on the meeting of the 7th of June 2017 set out what was discussed at the meeting. So which one was it?
I think, well, the meetings, there were 2 meetings. Again, the minority judgment, they've read my explanation. The first meeting was a meet and greet. It had nothing to do with the investigation. The second meeting of June, that's where the meeting with the presidency, which was requested by them in the first place. It's not the public protector who requested the meeting. And they responded to a Section 79 notice like any other one, but they said we would want to explain ourselves. And when they were explaining themselves at that meeting, that's where those notes were recorded.
So there was one note in particular about the vulnerability of ABSA.
I think it's not that one. That one is the meeting with the State Security Agency. And they were the ones who were raising the report of, in fact, the discussion of the report of Heath, who was saying, I cannot issue recommendations, or the monies cannot be recovered because it might have the run on the rent. So I think that's what I'm saying, that the minority judgment took all those explanations and all those written notes. Unfortunately, then there's that different perspective. So, but I think what we need to focus on, which I'm here for, is being the Ombudsman, the president of AOMA, and how we operate, and what are the challenges we are facing. Because yes, the challenges we are facing as South Africa are relating to this, but then in other countries, they've got their other challenges, especially.
I mean, as I said to you, Public Protector, that we are going to look at that largely, but we are also going to look at some of the issues here at home, talking about transparency, what some would say is a securocratic approach of the law. But don't go away. You're watching African Perspective. We'll be back with the Public Protector Advocate, Busisiwe Mkhwebane.